Good morning. I'm Bonnie Gardner. I'm co-chair of the Public Affairs Forum of the First Unitarian Universalist Church of Austin at 4700 Grover Avenue. Our forums are free and open to the public, and we encourage you to attend. For more information, you can go to our website at www.austinuu.org. We're going to have a talk on a very important social policy issue today, which goes right to the heart of what our country is about. And our forum committee member, Gary Bennett, is going to introduce today's speaker. Thank you, Gary.
Jordan Steiker is Judge Robert Parker Chair at the University of Texas School of Law. He received his BA from Wesleyan, where he was Phi Beta Kappa in 1984 and graduated magna cum laude from Harvard Law School in 1988. He clerked for the Honorable Louis Pollock, U.S. District Court, and Justice Thurgood Marshall of the U.S. Supreme Court. He's taught constitutional law and death penalty law at University of Texas since 1990, and is co-director of the law school's Capital Punishment Center. He was a visiting professor at Harvard Law School in 2003. He's written extensively on federal habeas corpus and the death penalty, and he's also represented a number of indigent death sentenced inmates in state and federal court. He served as counsel or co-counsel in many cases before the United States Supreme Court, and still has a perfect record that the court has ruled favorably for the defendant in all of those cases. He is chairman of the board of the Texas Defender Service, a nonprofit organization that represents indigent death-sentenced inmates, provides resources to attorneys working on capital cases, and dedicated to improving representation in Texas capital cases. He's also a personal friend. Go back to years when I was sponsor of the chess club in high school, and he was president and first board, and reconnected with him when he was speaking to a very large group in Cheltenham in 2003, just before we moved here. Literally, when we moved to Austin in 2005, aside from our real estate agent, he was the only person in town we knew. I give you Jordan Steiker.
Thank you very much, and good afternoon. It's a pleasure to participate in such a distinguished program. It's a special pleasure to be invited by Gary Bennett. As he mentioned, he was a former mentor of mine in high school, so all errors in this presentation are, of course, his. So my talk this afternoon is going to be about the status of the American death penalty. And that status has changed considerably over the last 10 or 15 years. 10 or 15 years ago, the central question that most people would ask about the American death penalty concerned the status of American exceptionalism. Why was it, and why does it remain the case, that the United States is the sole Western democracy that retains the death penalty? What accounts for our outlier status in that regard? And the conventional wisdom going back to that time, and really continuing today, was captured in two different kinds of accounts of American exceptionalism with respect to the death penalty. One sort of account would focus on American culture and history. This account would focus on the fact that the United States experiences a much higher rate of violent crime, that we have much greater racial division than other Western democracies, that we have a history of the frontier and the imagination related to the frontier, which creates its own distinct pressures, that we had the experience of lynching in the late 19th and early 20th century. And so the cultural account would look at all of these things. In addition, the American fascination with guns, the high level of religious fundamentalism in the United States, and there's a near perfect overlap between the Bible Belt and the Death Belt in terms of executions in the modern era. So this sort of account would say there's something distinctive about American culture and its history that accounts for why we retain the death penalty and still execute offenders, whereas all of Europe, all other Western democracies, Latin America, have long abandoned the practice. That's one sort of account. The second kind of account would focus on the structure of American politics. We have a federal structure. We don't have as strong a central government as most Western democracies. Criminal justice issues in particular are decided at the state and local level. And so one explanation for American retention is just the fact that we have 51 criminal justice systems, the 50 states and the federal government, and we have a widely differing array of arrangements. We have 18 states that do not have the death penalty at all. We have, of the 32 states that do have the death penalty, we have very different degrees of robustness. Some states that have barely sentenced any offenders to death. Some states that have sentenced large numbers of offenders to death, like California and Pennsylvania, but have carried out virtually no executions. Other states like Texas and Virginia and Oklahoma and Florida that have sentenced many offenders to death and actually carried out substantial numbers of executions. So this account would say, the reason the United States is different with respect to retention is we just don't have the same kind of centralized, bureaucratized, at the national level, criminal justice policy. Criminal justice in particular has been highly politicized, and we have district attorneys who are elected. We have judges throughout most of the country who are elected, so that there is sort of a much greater level of populism in the United States, and that sort of accounts for why the death penalty persists in the United States, where it's been abandoned throughout the world. Now, I think both of these accounts have a lot to recommend them, but I think that they're flawed in many ways as well. The cultural, historical account of United States retention strikes me as somewhat odd, because the divergence between the United States and the rest of the Western world is a very, very recent vintage. If you looked at the United States and its position with respect to the death penalty in the early 1970s, and at any time before the early 1970s, you would have thought that the United States was pretty much on the same track with the rest of Western Europe. And in fact, with respect to many developments and ameliorations of the American death penalty, we were in advance of our European counterparts. So if you look at the project of reforming the death penalty from the 1780s until the 1970s, the United States was an outlier, but an outlier in its restriction and sanitization, in some ways, of the death penalty. So at the time of the founding of our country, we were the first jurisdiction to try to distinguish between different kinds of murders. So you all hear on television and in the news about first-degree murder, second-degree murder. That invention was a Pennsylvania invention, and the explicit purpose of creating degrees of murder in this country was to make it possible for some people who committed murder to avoid the death penalty. So anything less than first-degree murder would not be punished by death. In the 1800s, in the early 1800s, the United States was again at the head of the pack in eliminating the mandatory death penalty and allowing for consideration of individualizing circumstances and allowing jurors to exercise mercy. So beginning really in the early 1800s and continuing through the early 1900s, the United States gradually abolished the mandatory death penalty. The United States also was at the forefront in terms of changing execution methods to make the death penalty less horrific of a practice. So we moved from hanging to the use of the gas chamber, to the use of firing squad, to the contemporary use of electrocution, and then to lethal injection. And all of these steps along the way were intended to make the death penalty more humane, less painful to the offender, less destructive of the body. And again, we were ahead of most of our counterparts in that effort to humanize executions. Some American jurisdictions, Michigan in the 1840s, Wisconsin in the 1850s, were some of the very first jurisdictions in the history of the world to abolish the death penalty. So all of that together makes it very hard to say that it's somehow built into the American DNA to say it was destined that we would be the country that would have the death penalty into the 21st century, when for most of our history, we were either at the same point or slightly ahead of Western democratic counterparts in the limited use and in the progressive reform of the American death penalty. So what about the second account, the political account that says, well, it's American federalism. It's the fact that we don't have a national criminal justice policy. It's just every jurisdiction has its own politics, and therefore it's natural or expected that there would be deviation, with some jurisdictions being retentionist, others being abolitionist. That's really the best explanation. The problem with that explanation is we came extremely close in the 1970s to nationally abolishing the death penalty. In 1972, after having gone half a decade without any execution in this country, the United States Supreme Court invalidated all existing capital statutes on federal constitutional grounds. So while it's true that we don't have a national parliament that decides criminal justice policy, or a European Union that, for example, makes a condition of membership the abolition of the death penalty, we have a United States Supreme Court, and our court really serves that function of creating or recognizing sort of national norms. And in the Eighth Amendment context, which is the prohibition on cruel and unusual punishment, the Supreme Court has focused on whether or not particular practices are consistent with evolving standards of decency. So the Supreme Court in 1972 said all of the existing statutes which were deemed excessively arbitrary were struck down, and we could very well have ended our experience with the death penalty as of 1972. In fact, the headlines the next day in most of the national newspapers indicated a belief that this was the end of the long road up from barbarism. This was the end of the American death penalty. It turns out that that was a particularly inauspicious time for the Supreme Court's intervention, because it came at a time in which the Supreme Court's political capital was quite limited on the heels of desegregation litigation in the same era as Roe versus Wade. It also came at exactly the time in which violent crime rates in the United States were rising dramatically. And so there was a tremendous backlash to the Supreme Court's intervention in 1972. 35 new states passed capital statutes after the Supreme Court's decision. And in 1976, the Supreme Court retreated somewhat and upheld many of the new statutes that had been passed. And from that period on, we've had the death penalty as a fact of American life. So you can tell that I'm somewhat resistant both to the culture and history story of American retention and to the American politics story, because I think that it's highly contingent and not sort of necessary or determined that we actually continue to have the death penalty today. It's easy to imagine counterfactuals where the United States was one of the first Western nations to abolish the death penalty, and that it might have done so with some level of sort of pride and sort of a way of declaring our outlier status, which was consistent with our outlier status through much of our history. What I do want to talk about today, and what I think explains our present situation, and what I think is a quite different situation than it was even 15 years ago, is what I view as the uniquely distinctive aspect of the American death penalty. And the uniquely distinctive aspect of the American death penalty begins in the mid-1970s, when the United States Supreme Court chooses not to abolish the death penalty, but does choose to embark on significant constitutional regulation of the death penalty. So what we've had since 1976 is something that no nation in the history of the earth has ever had, which is tremendously complicated, intricate regulation of how capital punishment is administered in the United States. Now, when I was first involved as a scholar with the death penalty in the early 1990s, I looked back at the system of regulation that had been produced in the mid-1970s. And I viewed the system of regulation as truly terrible along two dimensions. On one dimension, it turned out that by the 1990s, even though there was this very complicated set of Supreme Court commands for how states would operate their capital systems, it turns out they were extremely minimal in their actual requirements. States really didn't have to protect particular groups or individuals from execution. The Supreme Court rejected a ban on executing juveniles. It had rejected a ban on executing people with mental retardation. It didn't require much in terms of representation. The Supreme Court said the representation required in capital trials was no different from that required in any other serious felony kind of case in the United States. Supreme Court didn't really demand very much, but it had a tremendous number of decisions that regulated minutia that weren't in the end all that significant to the overall fairness or accuracy of the death penalty. So writing in that time, in an article that I co-wrote with my sister, who's also a law professor and also interested in the death penalty, we wrote that the Supreme Court actually managed to create the worst of all possible worlds, because it had this intricate set of regulation that meant a lot of interaction and friction between states and the Supreme Court that gave the appearance that the Supreme Court was substantially regulating the death penalty, but the actual demands were quite minimal. And so it gave comfort and sort of allowed the American people and a lot of different audiences to believe that the death penalty was really being taken care of. In our language, we said that the Supreme Court had really legitimated capital punishment. It had become a somewhat illegitimate practice by the end of the 1960s, where there was no regulation whatsoever. The Supreme Court intervened, and we described that intervention really as a fig leaf. It looked to the outside world like the Supreme Court was making sure things were being done fairly and accurately. In fact, the system wasn't much better than the system that had been replaced, and it created a much greater level of sort of comfort with how the death penalty was existing in the United States. And sort of some of the evidence that we threw out as sort of illustrations of this worst of all possible worlds aspect was the fact that clemency, for example, virtually disappeared in the post-1976 era. Before 1976, clemency was a common practice in about 20% of capital cases in Texas and elsewhere. Governors, boards of pardons and paroles would intervene and would give commutations. Post-1976, when the Supreme Court was viewed as being in charge of the practice, clemency sort of dropped off the table. In Texas, we've had 2 commutations and we're about to have our 500th execution probably this year. So the numbers of people who would be receiving sort of a close second look dropped precipitously because everyone thought the Supreme Court was in charge, was supervising. We had less reason to be worried about the American death penalty. So writing in the 1990s, my sister and I viewed the regulatory regime which we had inherited as both unusual but sort of unusually ineffective in actually making the death penalty system better. So what's happened in the last 15 years? Because if you had asked us in the mid-1990s, what's the likely course of the American death penalty, we would have said it will continue in this somewhat robust form for the foreseeable future. It seemed well entrenched. It had escaped the bullet of Supreme Court abolition in the 1970s. There was a wide constituency of support for the death penalty. Death sentencing reaches its absolute national high in the modern era in 1995, when we have about 300 or so death sentences per year nationwide. Executions reached their absolute modern era high in 1998 and 1999, when we reached close to 100 executions nationwide per year. So the death penalty system looked quite stable. Well, a number of factors contribute to the instability, including the regulatory regime that we had observed to that point. So let me talk about some of the destabilizing factors that we've seen over the last 15 years, and the reason why the death penalty is probably more precarious now as a practice than it has been in our entire history. And the likelihood of nationwide abolition of the death penalty, I believe, has risen to an extraordinarily high level in the foreseeable future. So first, in the late 1990s, there was the discovery of many innocent people sentenced to death on Illinois' death row. Illinois was a robust death sentencing state. It had sentenced close to 200 people to death in the modern era. It was not a robust executing state. It had executed only 12 people by the end of the 1990s, but it was a shockwave when it was discovered that there were 13 innocent people on Illinois' death row. And it didn't seem like a good batting average to have more people exonerated than people executed in the state system. And Governor Ryan, the Illinois Republican governor, asked for a moratorium, insisted on a moratorium of executions so that the Illinois could study what caused so many people to be wrongly condemned. And after sort of a blue ribbon committee investigated the practices in Illinois, ultimately there was a decision in Illinois recently to abolish the death penalty. It was decided that the risk of error really couldn't be cabined enough to justify continued retention. But that experience in Illinois, the experience with wrongful conviction, certainly changed at some level the national mood about the death penalty and people's sort of belief that the Supreme Court and its regulation was ensuring sort of accuracy in the system was dealt a pretty difficult blow by that experience. What happens also during the period that I'm talking about, and that we didn't perceive when we were writing in the 1990s, is that there was a tremendous change in the practice of the death penalty on the ground that was caused by, but not demanded by, the Supreme Court regulation. And let me try to explain. In the 1960s, before the Supreme Court intervened at all, capital cases were tried just like other ordinary cases. There were no such thing as capital trial lawyers. There wasn't a distinctive practice related to the death penalty. Lawyers who took these cases in Texas were appointed. Some of them were experienced criminal defense lawyers. Some of them were divorce lawyers and wills and trust lawyers, whoever happened to be available for these cases. But when the Supreme Court began to regulate, it demanded, or it asked for, a punishment phase in which defendants could present all different kinds of mitigating evidence. It wasn't a huge requirement to allow defendants to present this evidence, but it dramatically changed practice. So instead of having one lawyer at trial, now there would be two lawyers. By the mid-1990s, in addition to two lawyers, you'd have all kinds of specialists aimed at presenting the defendant's side of the case. Mitigation specialists, a group of people who didn't exist before the 1980s and 1990s began to emerge. And ultimately, capital trial practice became a much larger and substantial practice than it had ever been before. One of the things that happened as a corollary to the change in capital practice was the dramatic rise in the cost of capital cases. In the 1970s and early 1980s, capital cases cost significantly less than sentencing an offender to prison for the remainder of his life or for a lengthy term of imprisonment. And so it had always been, through most of the 20th century, a pro-death penalty argument to talk about the cost of the capital litigation. That changes dramatically by the 1980s and 90s, and certainly coming into the 21st century. It's now well established that the costs of capital litigation are tremendously high. I mean, it's hard in some ways to convey just how much more expensive it is to litigate capital cases, both at trial, in state post-conviction, where you have a right to a lawyer only if you're sentenced to death, in federal habeas litigation, where you have a right to a lawyer only if you're sentenced to death. I think the best way I can illustrate this, and this is somewhat dramatic, is in California, where they had a proposition that was just narrowly defeated to abolish the death penalty last fall. There was research done to try to figure out how much more expensive was it to sentence people to death in California than to sentence them to life imprisonment. And they tried to calculate all of the costs. One of the huge costs in California, which has also become a huge cost in Texas, is just the cost of death row incarceration. In Texas and in California, death row incarceration is all supermax 23 hours of a day in an individual cell for a person sentenced to death. No physical contact with any other human beings. The cost of that kind of incarceration in California is about $80,000 or so a year per inmate, as compared to the $16,000 or so it costs to incarcerate someone in the general population. So in California, they added up all of the costs of the 700 or so people on death row, divided it by the 13 executions they've had in the modern era, and the cost per execution in California was $250 million per execution. So the experiment with regulation, which created a new group of capital trial lawyers, capital post-conviction lawyers, advocacy groups, has dramatically raised the cost of capital punishment. And it turns out that that's changed the discourse, the way in which Americans talk about the death penalty. If you go back to the 1960s, people who were pro-death penalty were seen as the hard-headed realists who would say, we support the death penalty because of deterrence, because of cost, for sort of utilitarian, economic, practical, pragmatic considerations. And opponents of the death penalty would speak in general terms about human dignity, the relationship between the state and the citizen, and how it was inconsistent with those ideals to retain the death penalty. Today, the kind of discourse has totally reversed, in which opponents of the death penalty, which is now a much larger coalition, it's no longer people who even necessarily call themselves abolitionists, and folks who are trying to get rid of the death penalty in various states no longer call it an abolition movement, they call it a repeal movement, in order to take away the sort of larger, sort of moral imperative type arguments, which may be off-putting to supporters, and instead argue in very pragmatic terms about costs, about opportunity costs. In California and in Colorado, where there have been recent repeal efforts, the focus has been on, if we get rid of the death penalty, here's what we will do with the savings. And in Colorado and California, they said, we will dedicate some of the savings to solving unsolved cases, cold cases. We will serve victims in a much better way than the death penalty currently serves the families of victims. So on the opposition side, we now have pragmatic, utilitarian, sort of hard-headed kinds of reasons to get rid of the death penalty. And since it turns out that the deterrence argument has never been particularly persuasive. Supporters of the death penalty have moved away from arguments about cost. They've moved away from arguments about deterrence. And they argue just retribution demands the death penalty. We have to have this kind of punishment for the worst of the worst offenders. And in that kind of debate, there's been increasing support for the more sort of pragmatic, policy-oriented kind of advocacy than for the sort of larger moral, retributive arguments on the one side or dignity arguments on the other. So the debate has shifted. And that's what I think accounts in part for the success of the repeal efforts. 6 jurisdictions have gotten rid of the death penalty in the last 7 years. New Mexico, New York, New Jersey, Illinois, Maryland, Connecticut. I don't know if I mentioned any of them twice. Those 6 states have all repealed the death penalty. They've avoided making the repeal based on sort of straightforward moral arguments. And indeed, in some of those jurisdictions, for example, New Mexico and Connecticut, when they repealed the death penalty, they did not repeal the death sentences of the people currently on death row. It's a prospective decision where so it's up in the air whether or not the 2 people currently on New Mexico's death row or I think there's a dozen or so people on Connecticut's death row, whether they actually will face execution. I mean, I doubt that they eventually will be executed, but it shows a shift in the debate. What else has happened? Well, regulation has taken a turn towards much more substantive regulation than during the first 2 decades of regulation. I mentioned earlier that in the 1980s, late 1980s, the Supreme Court upheld executing juveniles and persons with mental retardation. Beginning in the 21st century, the Supreme Court reversed those decisions. So in a case called Atkins versus Virginia, the Supreme Court reversed this decision and held that it was unconstitutional to execute people with mental retardation. And what was most interesting about that decision was not simply the fact that it overturned a very recent decision to the contrary, but the Supreme Court's methodology changed significantly in that decision. It used to be that the Supreme Court, in deciding whether a practice was inconsistent with evolving standards of decency, would simply count the number of states that allowed the practice. And at the time of the first decision with respect to mental retardation, there were only 3 jurisdictions that said you can't execute people with mental retardation. Things changed a little bit in the interim, so that by the time the Supreme Court addressed the issue again, it was now 18 states out of 38 capital states at the time that prohibited the practice. But that still was a minority of even the death penalty jurisdictions that disapproved the practice. What the court said is not so much the number of states that prohibit the practice, but the speed and direction of change. We were moving towards a regime that rejected executing people with mental retardation. But the court also dropped a footnote and said, some other things are relevant. World opinion is relevant to our decision. Expert opinion, the American Psychiatric Association, the American Psychological Association, had all weighed in against executing people with mental retardation. The Supreme Court said opinion polls can be an indicia of evolving standards of decency. So the Supreme Court adopted a methodology that was much less focused on just sort of a legislative headcount and sort of opened to a much broader array of considerations. That methodological shift, as you can imagine, drew dire dissents from supporters of the death penalty. And Justice Scalia says, thank God we aren't governed by the European Union. Why should we care what the European Union says about executing people with mental retardation? By the way, the European Union, in most of these cases, would file an amicus brief. They filed a brief in that case saying this practice should change in the United States. So there was some question about, well, is this a permanent change in methodology? Is the Supreme Court really going to focus on world opinion and polling and expert opinion as it decides the constitutionality of these issues? Well, just a few years later, when it came to the case involving juveniles, the Supreme Court again cited the fact that we were literally the only jurisdiction in the world that authorized the execution of juveniles at the time of that decision. The only country that hadn't weighed in was Somalia because it did not at that time have a functioning government, but every other government in the world had rejected executing persons who were juveniles at the time of the crime. And Justice Kennedy, who wrote for the majority of court, said this is a relevant consideration in deciding evolving standards of decency. So the court has created a methodology that's much more conducive and open to evaluating how things happen on the ground. The court also said, it turns out we don't execute very many juveniles, and it's really confined to just a couple of states, Texas being the leader at that time. The Supreme Court also said, we care what jury behavior is. If jurors are consistently not returning death sentences in cases involving people with mental retardation, people who are juveniles, that's a relevant consideration. So over the last 7 years, we've seen dramatic declines in the practice of capital punishment in this country. We went from an average of 300 or so death sentences nationwide per year. Over the last 3 years are the first years in the modern era where that number has fallen below 90. So the last couple years, we have about 76, 77 people sentenced to death per year nationwide, which is becoming a vanishingly small number when you consider that the number of homicides hasn't really changed all that much. We have about 16,000 homicides nationwide in this country. And for those 16,000 offenses to yield, they're not all death eligible, but for that pool of offenses to yield something like 75 death sentences a year means that the death penalty is becoming much less significant part of the criminal justice process. Here in Texas, if I had given this talk a week ago, I could have said that no one has been death sentenced in Texas this year. We had our first death sentence 5 months into the year just this past week. And this is a change from the 1990s when we had over close to 36 death sentences per year in Texas. From the mid-30s down to, so far, 1. There are other capital trials likely to start, but the number of death sentences is also declining. So the practice in the United States, in part because of the cost of regulation, in part because of somewhat changing attitudes, the death penalty in the United States is increasingly fragile. And the Supreme Court has now created a methodological approach that is much more conducive to a permanent constitutional decision that would remove the death penalty from states' arsenals. And a lot of people ask when I've spoken about the death penalty, well, won't we have the same kind of backlash that we had in the 1970s? If the Supreme Court says no more capital punishment, won't the states, scream loudly and the Supreme Court won't capitulate again? And the difference this time, and I really think it's a profound difference, is the experience of a 4-decade effort at regulation. In other words, the critique of the death penalty internal to the court has been about this failed experiment. Some of the original architects of the system of regulation, by the end of their careers, ultimately found that the death penalty can no longer be constitutionally administered. Justice Blackmun was one of the folks in 1972 who said, we shouldn't abolish the death penalty. He said it violated all of his personal beliefs, but he didn't see a constitutional basis for doing so. When he retired in the 1990s, he said, I shall no longer tinker with the machinery of death. I don't believe that the death penalty is capable of being administered in a consistently fair and non-arbitrary way. Justice Stevens, who in 1976 was one of the people who supported the death penalty, embarked on the system of regulation at a time of his retirement just a few years ago, said the death penalty is so infrequently administered that it can no longer serve any significant penological purpose. And he also gave evidence of the fact that we strive so hard to take away any pain from the moment of death that it reflects sort of some deep ambivalence about what the function of the death penalty is and what it could possibly serve. So I believe that we are entering an era where the death penalty's days are truly numbered and the practice is dwindling everywhere, not just in places like New Jersey and Illinois and New Mexico where they've repealed the statutes, but even in the heart of the death penalty death belt. In places like Texas and Oklahoma, in Virginia, the number of death sentences, the numbers of executions are declining. The decisions by local district attorneys to seek death are declining, and I think we are ultimately headed for a period of Supreme Court abolition. Thank you.
Thank you. We have a question here.
I'm Crockett Graby. I wanted to ask you a question about the regulation that courts are using versus the reliability of the conviction. And I think that's a very important part because, for example, a few years ago here in Texas, there was a man who was executed for setting fire to his own home and killing part of his family. He was accused of that, and he may well have been innocent. I mean, the evidence was very ambiguous at best. So I want to know if that can be a regulation on to stop a lot of these death penalties.
So there's a lot of concern about wrongful convictions, and in the case of Cameron Willingham, a possible wrongful execution. I think one of the things that has been destabilizing for the death penalty, but destabilizing for criminal justice generally, is the experience of uncertainty following the greater accuracy of some forensic sciences. So the ability to test DNA much more precisely in the late 1990s is what led to the discovery of many wrongful convictions. They would just be able to retest evidence that previously couldn't yield definitive answers. But that's not the only forensic field where there's been tremendous strides away from what was previously fairly characterized as junk science. So the science surrounding arson investigations was not very good in the 1970s and 80s. And it was a poor science that, even as poor as it was poorly administered. So some people who were in charge of those kinds of investigations and who would be hired to testify in cases often didn't have the level of expertise or competence to do the kind of job that we want. So I think that does put pressure on the death penalty. I think the fact that we've had better science that reveals errors makes people realize that nothing is infallible. And I don't think it's created a sense that, well, going forward, now we have the science, now we'll be infallible. I think the experience has been that there's been a sort of an audit of those cases, and there's a lot of things in human nature that have been discovered in those cases. The way in which it's common for prosecutors or police officers to be too focused on particular suspects, to be unwilling cognitively to deal with evidence that creates dissonance with their prior understandings. All of those kinds of sort of psychological phenomena, I think, make it hard to have the kind of certainty that people think is required if you're going to administer a death penalty.
I have two questions. The second question you almost answered, and that is, I would have thought that the DNA was not just one of those forensic factors, but that was more dramatic, at least as far as the public was concerned, because so many could be reversed. Would you comment on that? But my first question is, what was responsible for the spike of belief in the capital punishment starting in the mid-70s? I'm going to propose an idea, and you can tell me if it has any validity. We began to have more and more drug problems in the country, convictions, and it was easy to assume that many of them were black, so the death penalty was necessary to put the lid on a broken society. Thank you.
Well, let me answer that question first. The 1970s was an important political moment, and you refer to race, and it was the beginning of the Southern strategy, in which it was an effort to politicize criminal justice in a way that it hadn't been politicized before, and to racialize criminal justice in a way that it hadn't been racialized as much before. And so I think there was a way in which support for the death penalty was aimed at dealing with what was viewed as sort of the breakdown of American society. I mean, I would say that the much more straightforward explanation for the rising support of the death penalty was the dramatic rise in violent crime. We have now returned to the levels of violent crime of the early to mid-1960s, before the explosion in the 1970s through the early 1980s. So if you put a chart of violent crime and support for the death penalty, those charts are going to look a lot alike, and you can add a lot of other explanatory variables, but I'm not sure that they do as much work as just the sense of personal security. But it is also the case that I think race became a much more, the picture of the death penalty became much more a racial picture. And it turns out that when the Supreme Court actually addressed whether there was race discrimination within the capital punishment system, it turns out there was a very surprising answer. And the surprising answer was that with respect to the race of defendants, there wasn't tremendous amounts of discrimination. What it turns out really matters is the race of victims. White victims are much more likely to generate death sentences than minority victims. The police, the prosecutors are much more mobilized in white victim cases. And it also turns out that most homicides are intra-racial, white on white, black on black, Hispanic on Hispanic. So paradoxically, the indifference to minority victims made it much less likely that minority offenders were going to receive death sentences as white offenders. But that didn't change, I think, the public's misperception of the minority offender as sort of the central offender in capital cases.
Regarding mitigating evidence, could you comment on what kinds of mitigating evidence are most persuasive, like perhaps a history of child abuse, something like that?
Well, this is where the change in practice has been most dramatic. Before the 1970s, the only kind of evidence that an offender or a defendant would put on in a capital case would be evidence of mitigation related to the crime. Things like, was he provoked? Was he under the influence of alcohol? Was there something at the time of the crime that makes us feel that he was less culpable for his actions at that moment? Now, there's an understanding, and the ABA guidelines have become, require a much more and deep, comprehensive evaluation, a full social history of the offender. And that social history will include everything from relationships to family members, the existence of abuse, childhood records in schools, educational performance, educational deficiencies, all kinds of psychological testing related to intelligence, all kinds of psychiatric testing related to any kinds of mental illness, all of the relationships from the point of the birth to the time of the offense. So the type of investigation that's undertaken takes months and in some cases years, which is why there's such a separation between the time of an offense and the time that an actual capital trial goes forward. And so one of the interesting things that's happened is because the level of professionalism and practice on this side has changed so dramatically, lawyers do this even in advance of trial in order to obtain a plea. So they'll do their full investigation, find out all of the possible mitigating evidence that they might put on at a capital trial, and then go to the prosecutor's office and say, this isn't a death case. There is substantial mitigating evidence that gives some partial explanation of how this person went awry, and that's why this isn't one of the worst of the worst. And since you now have a dwindling pool of cases that actually go to trial, you can say, look, my guy's not as bad as those 3 people who have been death sentenced in the last 2 years in this county. It's crazy to go ahead with this case. And that's really changed, the level of practice has changed so much, and I think that's in part what has accounted for the dramatic more than 65% decline in death sentencing over the past 15 years. And so even in very highly aggravated cases, some of the cases that you may be familiar with, there was the case of Brian Nichols, the man who was on trial for rape in a courtroom in Georgia, and he ended up killing several people in the courtroom, escaped, kidnapped a woman, and finally gave himself in. This would have undoubtedly in the early part of the 20th century, been a lynching. By the late part of the 20th century, would have been a death sentence. It went to trial. It cost millions of dollars, and he received a life sentence. That's the kind of thing that would just never have happened, 15 or 20 years ago. In Houston, we had an undocumented person kill a police officer in a stop in Houston, went to trial, and got a life sentence. Again, that's something that would never have happened in Harris County, 15, 20, 30 years ago.
Thank you. This was an excellent presentation. My name is Douglas Bauer. I'm part of the Forum Committee here. The U.S. Constitution, and I'm paraphrasing, has a ban against cruel and unusual punishment. Could you comment how that factors into current laws and Supreme Court's thinking?
From a constitutional perspective, just a little overview. Some folks would say the Constitution clearly allows for capital punishment. There are provisions in the Constitution that presume the existence of the death penalty. The Due Process Clause, which we think of as sort of the fountain of liberty in the 5th and 14th Amendment, says no life, liberty, or property shall be taken without due process, but the implication is that if you have due process, that the state can take away life, liberty, or property. But notwithstanding the sort of that textual support for the death penalty, the Supreme Court first approached these issues through the lens of the Due Process Clause, which is the lens through which most of constitutional criminal procedure has been established. And in the death penalty context, in 1971, all of the existing statutes were challenged as a violation of due process. The argument was the state statutes gave no guidance at all to juries as to who should live or die, therefore it should be deemed unconstitutional. And the Supreme Court said it doesn't violate due process, but a year later it took the same challenge under the 8th Amendment. And since that time, it has anchored virtually all of the challenges in the death penalty context to the protection against cruel and unusual punishment. And so beginning really in 1972, the court created what in shorthand has been called the death is different doctrine, that even though we will tolerate all sorts of procedural irregularities and lower levels of protection in the non-capital context, in the capital context, because death is different, we demand a higher level of reliability, and that's really been the source of most of the constitutional regulation. It's also the source of the proportionality guarantee. So when the court says you can't execute juveniles, you can't execute people for the offense of rape, you can't execute people with mental retardation, that's all been interpretation of the ban on cruel and unusual punishments, that it's that carries within it a guarantee of proportionality. And I think ultimately that will be the basis for the Supreme Court's decision to invalidate the death penalty as a practice.
I know there have got to be more questions. Are there? Okay, right here. Would you stand?
I'm Carl Wellman, and my question is, as the regulatory and financial arguments become more prominent in repeal efforts, what, if anything, is given up as that happens? For instance, is the movement to repeal the death penalty exposing itself to future givebacks should the process become less expensive and less regulated?
I think that's an excellent question, and it's a troubling question, because when you're no longer on the grounds of human dignity, you're no longer on the ground of sort of basic human rights, then everything's just a practical consideration, and I think it is worrisome. One obvious and connected issue is the question of whether or not life without possibility of parole is a punishment that people who have concerns about the death penalty should embrace. Right up until this point, opponents of the death penalty have been advocates in favor of life with possibility of parole on the grounds that fewer people will be sentenced to death. It's the best way to diminish the frequency of the use of the death penalty. Unfortunately, the widespread adoption of life without possibility of parole came at about the same time as the death penalty in 1970 was struck down. A number of states then thought that their only option was to have life without possibility of parole. We now have thousands and thousands of people serving life without possibility of parole who wouldn't be serving it had there not been this flux with respect to the death penalty. So I think we do give up a fair bit by focusing on pragmatic questions. You know, we could have another era of great wealth or another era of great apparent wealth where we don't foresee the bubble, in which people say, you know, cost doesn't matter. We want justice. We want retribution. And if the only argument on the other side that remains is it's an inefficient and inexpensive practice, that's not going to resonate. One of the puzzling questions is why we don't have nearly the level of discourse around human dignity in this country that there is in our European counterparts. Human dignity has really dropped off as a basic argument against a lot of practices, against the humanity of the conditions of confinement. People sort of sigh when they hear about human dignity in Guantanamo. We really don't have a robust sort of human rights discourse in this country to match sort of the difficulties that some practices pose.
Just to take a final moment before we thank you for an outstanding presentation, what was it like to go before the Supreme Court?
It was very scary. It's a tremendous experience, but it felt like an awesome amount of responsibility to do a good job on behalf of the clients that I work with. And so, and the Supreme Court has been the one sort of major source of amelioration of the death penalty, but no one would mistake it for a particularly friendly forum for people advocating on behalf of criminal defendants. So it's a tough place to be. And if you're there, it's often at the end of the road where a loss means your client gets executed. It's not the beginning of the process. I mean, my advice to people, to law students who are concerned about the death penalty is get involved at the front end. Get involved. You lose a case when you go to trial. You want a plea. You want to avoid being caught up in the intricate, labyrinthian system that, for the most part, will result in your client's death.
It's heartening to know that there has been some gradual improvement over time, and we'll stay tuned. And again, thank you for coming and speaking with us. It's been an outstanding program.
Thanks very much.